Building on the previous section's discussion of stigmatized property and non-required disclosures, this section explores the specific disclosures that Arizona law does require in various property transactions. These disclosures are vital because they ensure that buyers are fully informed about conditions or legal circumstances that could impact property use, value, or safety. The Arizona Legislature and the Arizona Department of Real Estate, ADRE, have established multiple statutes and administrative rules mandating when and how these disclosures must be provided. Each disclosure carries unique requirements for timing, content, and responsibility. Failure to deliver them properly can lead to delayed closings, contract rescission, or disciplinary action under ARS Section 32-2153A3 for negligence or misrepresentation. One of the most common required disclosures is the swimming pool barrier disclosure, governed by ARS Section 36-1681. Arizona law requires that any property with a swimming pool or spa meet state and local barrier safety standards. This disclosure, typically included in the Arizona Association of Realtors residential resale real estate purchase contract, informs the buyer of their obligation to comply with safety laws and allows them to investigate local ordinances. The disclosure must be delivered prior to closing and serves to protect both the public and homeowners from accidental drownings. The licensee's role is to ensure the buyer acknowledges receipt of this disclosure and understands that compliance is a post-closing responsibility. Next, the planned community and condominium disclosure information is critical in any transaction involving a property governed by a homeowners association, HOA, or condominium association under ARS Section 33-1806 for planned communities and ARS Section 33-1260 for condominiums. Sellers must provide buyers with governing documents, bylaws, financial statements, and information on fees, assessments, and pending litigation. These documents must be delivered within 10 days after contract acceptance. The buyer then has a 5-day right to rescind the contract. After receiving the disclosure packet, licensees must carefully monitor this timeline to ensure compliance and prevent the contract from being voided. If your buyer states that they love the home because it has a RV gate, your question to them is why. Most HOAs do not allow RVs to be visible from the street even if they are behind the RV gate. The Notice of Soil Remediation is another specialized disclosure that arises under ARS Section 49701.02 and the Arizona Department of Environmental Quality ADEQ rules. If the property is located on or near a site where environmental remediation has occurred, such as removal of petroleum-contaminated soil or hazardous materials, the seller must disclose this information in writing before close of escrow. For example, if a home is located near a former gas station site where underground fuel tanks were removed, disclosure is mandatory to ensure the buyer can make an informed decision. Licensees should also verify property locations through ADEQ's online environmental registry when potential contamination is suspected. An equally important disclosure is the Affidavit of Disclosure, mandated by ARS Section 33-422. This disclosure is required whenever a property located in an unincorporated area of a county is sold and is not part of a subdivision that has already received a public report. The affidavit must be recorded along with the deed and includes essential information such as access to the property, water source, wastewater treatment, floodplain status, and legal access. It must be provided to the buyer at least 7 days before closing, and the buyer has 5 days after receipt to rescind the transaction if dissatisfied. The purpose of this disclosure is to ensure rural buyers understand the property's infrastructure limitations, such as private wells, septic systems, or unmaintained roads. The military airport disclosure and public airport disclosure are designed to notify buyers of proximity to areas affected by aircraft noise and operations under ARS Section 288484. Properties located within military airport influence areas must include a written disclosure identifying the location and potential noise or accident risks associated with aircraft operations. Similarly, ARS Section 28-8486 applies to public airports. These disclosures must be provided to the buyer prior to the execution of the contract. A practical example is a buyer purchasing a home near Luke Air Force Base or Sky Harbor International Airport. Failure to disclose proximity could lead to claims of misrepresentation. The Arizona courts have repeatedly upheld that noise and flight patterns constitute material facts when not properly disclosed. The subdivision disclosure got public report is another cornerstone of Arizona real estate regulation. Under ARS Section 322183, a developer or subdivider must obtain a public report from ADRE before offering lots or parcels for sale. This report discloses material information such as utilities, access, title conditions, and encumbrances. Advertising, selling, or leasing any parcel before the public report is issued is prohibited under ARS Section 32-2181. Licensees representing developers must ensure that no marketing begins until the ADRE has approved and issued the public report, and a copy must be given to each buyer before signing any contract or accepting earnest money. When construction or renovation work has been performed on a property for resale, additional disclosure obligations apply. Regarding contractors and the scope of work performed, licensees must ensure sellers disclose all known work completed by contractors, especially structural, electrical, plumbing, or roofing repairs. The disclosure must identify whether the contractors were licensed under the Arizona Registrar of Contractors ROC and provide details about the work performed under ARS Section 32-1121. Any person or entity performing contracting work for compensation must hold a valid ROC license unless exempted. Sellers who hire unlicensed contractors for remodeling or repairs before resale may face liability if defects later arise. For example, a seller who hires an unlicensed handyman to remodel a kitchen and later sells the home must disclose that the work was not performed by a licensed contractor. This disclosure protects buyers from unexpected repair costs and helps them evaluate the quality and legality of the improvements. Finally, in transactions involving wholesale deals or assignments, disclosure remains critical. When a buyer intends to assign a purchase contract or resell based on equitable interest, the licensee must disclose this intent clearly and in writing before closing, as discussed in House Bill 2747 and R4-28-1101B and ARS Section 44-5101. Failure to disclose equitable or assignable interest can result in disciplinary action and potential fraud allegations. Advertising such a property must specify contract interest for sale or assignment available rather than home for sale. Ensuring compliance with State Law Review Summary. This section covered the mandatory Arizona disclosures every licensee must understand and deliver in a timely manner. Key disclosures include swimming pool barrier disclosure, provided before closing, to inform buyers of safety compliance obligations under ARS Section 36-1681, HOA, and condominium disclosure packets, delivered within 10 days of contract acceptance per ARS. Paragraph 5 33-1806 and 33-1260. Notice of soil remediation, required before close of escrow for properties near or on remediated sites under ARS Section 49-701.02. Affidavit of disclosure, required for non-subdivided rural property under ARS Section 33-422 with a 7-day pre-closing timeline. Military and public airport disclosures must be provided before contract execution under ARS Sections 288484 and 288486. Subdivision public reports must be issued by ADRE before advertising or selling lots per ARS Section 32-2181. Contractor and ROC work disclosure identifies whether recent repairs were completed by licensed professionals under ARS Section 32-1121. Wholesale transaction disclosure requires written notice of intent to assign or sell equitable interest under House Bill 2747. Discussion. When must a seller deliver the HOA disclosure packet to the buyer? Answer. Within 10 days after contract acceptance, as required by ARS Section 33-1806. What is the purpose of the affidavit of disclosure for rural properties? Answer. To inform buyers about water, sewer, access, and floodplain conditions before closing under ARS Section 33-422. Why must buyers near Luke Air Force Base receive a military airport disclosure? Answer. To notify them of aircraft noise and accident potential within a military airport influence area per ARS Section 28-8484. Closing remarks. Disclosure is one of the most powerful tools of consumer protection in Arizona real estate. While stigmatized conditions may not require disclosure, statutory property disclosures are non-negotiable. These laws ensure transparency, prevent misunderstandings, and protect all parties involved in a transaction. As a licensee, it is your duty to understand each disclosure's content and timing, verify accuracy, and document delivery in writing. In every transaction, remember this principle. When in doubt, disclose early, disclose clearly, and disclose in writing.